By now, we have all heard that Judge Whitaker has denied all of the motions that the defense has submitted on behalf of the YSL defendants. She has denied motions for a mistrial. She's denied motions for removing of the prosecutors, etc., etc., etc. I want to focus on one thing. There have been other creators who have read this, but I want to try to give hopefully a unique perspective on this. I'm not sure anyone has talked about this from this angle, so y'all bear with me. Let me cook a little bit and see what you think about this take on Whitaker's decision. Let's talk about the part of her decision where she talks about whether or not there was a Brady violation. Now, just so that you can be totally clear, a Brady violation occurs when the prosecution has information that could either help the defense prove their not guilty status or could help the defense impeach a witness, basically call a witness's credibility into question. So when the prosecution has that kind of evidence, they must turn it over to the defense. If they don't, very serious consequences can happen, including the trial could be totally eliminated. We could call it a mistrial with prejudice, which means when the mistrial is granted with prejudice, the case can never be retaken up again.
Ms. Bumpus, were you in the courtroom when Mr. Copeland was called to testify after the ex parte meeting? Were you present in the courtroom?
Yes.
Okay, did you hear Judge Glanville, did you hear him tell anyone from the defense that an ex parte meeting had occurred?
No.
Did you hear anyone from the state tell the defense on the record that an ex parte meeting had occurred?
No.
Was there any discussion about the substance of said meeting?
No.
Okay, thank you.
Anybody else? All right. Thank you, Ms. Bumpus. You are excused. Just for my knowledge, does anybody on the defense team have any other witnesses as to this issue?
Not for Mr. Kinder.
All right. Is the state going to have anybody?
If the court could just, I'm sorry for being obtuse, which exact issue is it that we are addressing? I know it's the June 10th, but what exactly are we addressing? So I can have.
I mean, the defense maintains that there was an unrecorded portion of this ex parte where Brady information was revealed to Ms. Hilton that Ms. Hilton did not then share. So that's our topic. Sure.
So let me read this from Whitaker, and then I'm going to compare this to certain types of crimes called inchoate crimes that all prosecutors and all judges know. And you be the judge. You let me know if you think this kind of amounts to it. I'm not saying that the Brady violation was a crime, but does this fall within the same kind of category of inchoate crimes? Not in that it's a crime, but that it's an attempt at something inappropriate or wrong. So first I'm going to read this just so that we have the context again. This has been a long-running and multifaceted proceeding. Challenges have been myriad and formidable. Frustrations may have been mounting while fortitude was waning. A needle in a haystack is not only sometimes difficult to find, but also easily overlooked. The court does not attribute bad faith to anyone on this issue. And yet, as soon as Copeland joins the June 10, 2024 in-chambers ex parte meeting, he states, "I have never been truthful a day in my life until I just made this statement right now." Copeland may have little credibility. He may speak in hyperbole, but the fact remains that for a defense attorney, this nugget by a key state's witness is gold. So when the prosecution not only did not reduce this statement to writing and produce it, but also asserted in court filings that the defense had no entitlement to know the contents of the ex parte proceedings, this amounted to suppression, whether willful or otherwise, of what was objectively Brady impeachment material. I'm going to pause here. How can you say willful or otherwise? If they're telling you, we didn't tell you this because you didn't have a need to know, that's definitely willful. It's not accidental, right? Let's continue. Now, she might say otherwise, as in maybe they didn't know it was Brady, but they still willfully held that back, right? If they didn't know it was Brady, they still willfully held it back. Let's continue. The defense now knows this statement and indeed of all of what occurred during the June 10th ex parte meeting. The contents of the meeting were ultimately revealed during the course of trial and in time for the defense to utilize it. So the failure to produce / suppression of this information does not technically amount to a Brady violation, but the fact that a violation of a defendant's constitutional rights has been averted does not, under these circumstances, provide cause for celebration. So here what I'm going to do is I'm going to introduce you all to the idea of inchoate crimes. Inchoate crimes are crimes of attempt. Okay? I'm going to read from ChatGPT. We're going to get a definition of inchoate crimes. So let me read. I'm going to now follow me here, right? These are actual crimes. Again, I'm not saying that the Brady violation amounts to a crime. What I am saying is that the attempt to do something wrong itself is something wrong. Here, Whitaker is treating the attempt to do something wrong, as long as the wrong itself is averted, the attempt to hide what happened during the ex parte meeting, as long as some kind of way it is brought to light at some point, then, we averted a disaster. Yeah, maybe we did avert a disaster, but within American jurisprudence, attempt at wrongdoing is often considered wrongdoing in and of itself and can have harsh penalties in and of itself. So inchoate crimes, also known as incomplete or anticipatory crimes, are offenses that involve actions taken toward committing a crime, but where the crime itself has not been completed. In other words, the crime is averted, right? The three primary types of inchoate crimes are attempt, like attempted suppression of Brady material. This occurs when an individual takes substantial steps. Now, mind you, they are all within this RICO trial. They are going to be arguing that YSL took substantial steps toward committing crimes. This occurs when an individual takes substantial steps toward committing a crime, but ultimately fails to complete it. They tried to suppress the material, but they were not successful. This is attempt. For example, attempting to rob a bank, but being stopped before entering. Or attempting to suppress Brady material, but somebody forcing you to turn it over. Or in fact, somebody else altogether turning it over. So then you have conspiracy. This involves an agreement between two or more individuals to commit a crime. And you have solicitation. This is the act of encouraging, requesting, or commanding another person to commit a crime. So my point here is Whitaker is treating the attempt at suppression of Brady material, the intent, the substantial steps that were taken. She's treating all of this as if it were nothing really, because at the end of the day, you did get the material. But this same judge, if you have somebody who attempted to rob a bank, if you have somebody who attempted to kill somebody, if you have somebody who attempted to commit a crime, this same judge would look at the statutes and probably even the common law history and say, okay, well, that attempt is not the crime that you attempted, but the attempt itself is a crime as well. So there's a penalty. And you know what that penalty is not? It's not watching some videos. So what did Whitaker decide that the prosecution needed to do? Like, what is their penalty? We've all heard this by now, but I'm just going to repeat it for anybody who's new to this. What Whitaker ordered, I'm going to go back to the order here. The court therefore orders as a remedial measure that the entire prosecution team working this trial submit to training on Brady and other professional obligations of a prosecutor. This training will consist of a video replay of training on this topic previously presented by the Prosecuting Attorneys Council of Georgia. The court will provide the video and the viewing will occur under the direction of the court. So imagine somebody has been charged with attempted crime, whatever it is. They were not successful because somebody else stopped them. Like, they didn't stop themselves and then turn back from the crime. They were attempting to commit the crime. They were attempting to do something wrong. Somebody else stopped them against their will, basically, because their will was to follow through with this crime. And then someone else stopped them. They were caught, and they go to the judge, and the judge says, "Oh, so you were attempting to steal that car? Okay, look, good thing you didn't actually steal it. Well, I'm going to sentence you to watching this video about why you shouldn't steal cars." I mean, just imagine this. Imagine this is a full-grown adult who's accused of a crime, who's been working in an industry where they know full well not to do this. They have, decades of experience in their life saying, "Hey, don't steal cars." They're caught by somebody else trying to steal a car. And when it's time for sentencing, the judge says, "Look, good thing you didn't actually get to steal the car. So why don't we sentence you to watching a video about not stealing cars?" Again, I'm not saying that the Brady violation was on the level of a crime. So that's not my point. People will say it's illegal. It's definitely unlawful, but I don't know if I want to use the word illegal. But it's inappropriate, it's wrong, and the sanction being something so light, I think is a joke. So anyway, I just wanted to bring that perspective to everybody. Let me know your thoughts in the comments. Don't forget to like and subscribe, and tomorrow's a big day, so we'll see you back for the next one.